Thank you, counsel. Ms. Hartnett.
Mr. Chief Justice, and may it please the court, Idaho concedes that HB 500 draws a sex-based line by categorically excluding all students with the biological sex of male from women's teams. Sex classifications like that are closely scrutinized under the Equal Protection Clause to ensure they rest on evidence, not supposition. Idaho's articulated justification for this line is to protect women's sports from birth-sex males because of their, quote, biological advantages. That means HB 500 is aimed at controlling for sex-based biological advantages, not for all of the many reasons one athlete may be better than another that have nothing to do with sex. On the preliminary record in this case, and as the experts below agreed, circulating testosterone after puberty is the main determinant of sex-based biological advantage that HB 500 sought to address. And on this record, Lindsay Hecox has mitigated that advantage because she has suppressed her testosterone for over a year and taken estrogen. HB 500 thus fails heightened scrutiny as applied to Lindsay and transgender women like her who have no sex-based biological advantage as compared to birth-sex females. That analysis would come out the other way for the untalented cisgender boy. He would have the same sex-based advantage, the circulating testosterone, he just would not be as good at sports. It also would come out the other way here, for example, if a transgender woman had gone through a male puberty and had not mitigated that advantage. This court's cases have recognized that when the government's justification for a sex-based classification does not apply to a discrete subgroup of those classified, that classification is unconstitutional regarding that subgroup. And that holding in Caban, which I'm sure we'll discuss further, has been repeatedly referred to and reaffirmed, including more recently than Nguyen and Morales-Santana. Because the court can affirm based on sex discrimination, it's not necessary to reach the question of transgender status discrimination, but HB 500 also fails on that basis. If the court does not find the case moot, the preliminary injunction should be affirmed. I welcome the court's questions.
Couldn't you make a similar argument with respect to Title IX itself and the sex difference, the fact that you can have male and female sports?
No, Your Honor. So I think the point would be, the question would be, would the sex line that's drawn in sports, and that's a line that does exist, as a commonplace line, is that substantially related to the important state interest
Well,
articulated?
you could have individuals who, for example, don't present the problem of physically outmatching women in a particular sport, or a group of people who don't.
Right, and the broader goal here, of course, is not sex separation for its own sake. The idea is to have equality in sports, and that's the ultimate objective that I think we're all talking about, not separation for its own sake.
Well, my point is the argument that you're making now with respect to this subcategory, could it not also be made with respect to the sex separation in Title IX generally?
Occasionally there have been examples of a boy challenging the separate teams because they want access to a team that's not available for the boys because of the way Title IX works. To be clear, we have not aware of an example of a boy challenging the sex separation so that they can be on the girls' team where there's a boys' team that exists. In that case, the courts do look at that under intermediate scrutiny, and they determine that the overall goal of ensuring equality in sport opportunity for women and men allows for the distinction.